Good morning, everyone, and welcome to today's webinar. This is Steve Young. It's my privilege to serve as Senior Vice President and General Counsel of the Independent Insurance Agents Brokers California. Today, we are very honored to have Todd Stitt, a partner in the law firm of Michelman & Robinson, LLP, joining us. Todd is the leader of Michelman & Robinson's Class Action and Complex Litigation Practice Group. He is also co-chair of the firm's very highly regarded insurance industry group. Todd is particularly well qualified to do this session today on errors and omissions avoidance because he has represented virtually every segment of the professional insurance industry. He has represented large national insurers, general agents, premium finance companies, claims adjusters, and of course, brokers and agents in insurance-related cases. He is very experienced and has a very successful track record in defending insurance industry participants against enforcement actions of the Department of Insurance and in litigation affecting or alleging errors and omissions claims. The firm, I'll just say, Michelman & Robinson, is one of several that does a lot of work in the insurance industry, but this firm is very highly regarded not only in California but nationally, and it's been my observation that not only is this firm populated by very good lawyers, but they're also populated by just really great people, and Todd Stitt is a perfect example of that today. So we're very honored to have him deliver this webinar for us. It is the second in a series of webinars that Michelman & Robinson and II-ABCal are producing for you. For today's webinar, I wanted to make just a couple of housekeeping comments. The first is that we are recording this session, and so you will have an opportunity to listen to it in the future if you missed something today, or if there are others in your agency or brokerage that you would like to have access to this later. The firm will be providing follow-up information probably in the next few days or next week following up on this session. And it's very important for you to know also that we have muted your phones to ensure that there is no background noise, but you do have the opportunity to ask specific questions throughout the webinar by typing them into the question panel that you'll see on your screen. So I think that's it for the preliminary comments. We're very happy to have all of you with us. We're especially honored to have Todd Stitt deliver this presentation on E&O. So Todd, take it away.
Thank you very much, Steve, for that introduction. I appreciate it very much. I want to thank everyone for being here today and joining this morning on the webinar. As Steve mentioned, this is a 4-series. I just want to point out briefly that in following this, the next 2 will be unemployment related with Spencer Hamer and trade secret with Jeff Farrow. So I highly recommend you attend those as well. As Steve also mentioned, the material that you'll be seeing, the firm will make available via email. So if you want a hard copy of what you'll be seeing, happy to have it, and we will send that to you. As Steve indicated, what I'm going to be talking about is errors and omissions, and it was originally titled Protecting Against Errors and Omissions, and I changed it up slightly to Protecting Against Errors and Omissions and What to Do When a Claim is Made. And the reason for that is that I think the two can't really be broken apart. Unfortunately, in the litigious world we live in today, E&O claims, just like any litigation, are becoming more and more prevalent. So I thought it important to talk about not only what may be an E&O claim, how to protect yourself against the E&O claim, but when it does pop up, what type of steps you want to take. So with that, why don't we get started? First slide talks about what the most common errors and omission pitfalls are. So these are the 4 areas I'm really going to talk about today, but I want to point out a couple things. Number 1 is that what you see here, we're talking about the failure to obtain sufficient policy limits, failure to properly recommend types of coverages, obtaining the actual requested insurance, and failure to add additional insureds. That represents really 95% of the E&O claims we see. There's outliers such as issues relating to cancellation of policies and those duties, dealing with non-admitted carriers, for example, sub-agent issues. There's a variety of other types of claims that pop up. But in the world we live in and what we see, 95% of E&O claims are going to fall within one of these four categories for independent agents and brokers. So I'm really going to focus my attention to these. If someone has a specific question, either today or later with respect to other types of activities, feel free to email me, feel free to call me, and I'll be happy to help. Another important issue I want to raise just before we get started, I understand everyone on the call has a very good sense of the difference between an agent and a broker, who their responsibilities lie to, and where that might be impacted on a day-to-day basis. So I'm not going to really get into that. That's not really the purpose of the presentation. I did want to make the general highlight, of course, that with respect to agents, the agents are generally acting on behalf of the insurer. The insurance brokers are generally acting on behalf of the applicant. There are a couple distinctions throughout this presentation as to how and what impact might be with respect to a broker or with respect to an agent. So there are some differences. There's a lot of similarities. But again, if questions arise as to what the difference might be that isn't addressed in this particular presentation, feel free to let me know or give me a call. All right, the first issue that I pointed out, the most common pitfalls, is the failure to obtain sufficient policy limits. Out of everything I see, this is probably the most common, which is the insured has a loss and the insured ultimately claims that there is not sufficient limits with respect to the policy to cover that loss. With respect to an agent generally doesn't have a duty to volunteer to the insured that they should have additional coverage. The reason for this is pretty straightforward. The agent's acting on behalf of the insured. The agent is not acting on behalf of the insured. They're really simply taking the order. If the insured calls up, the insured comes in, whatever the case may be. The reality is that insurance agent is simply taking that order and passing it on to the insurance company as its agent. So typically, under normal circumstances, there's not going to be liability if there's insufficient policy amounts. Generally, the same rule applies with respect to brokers. There isn't a duty to volunteer to the insured that they should get additional coverage. Again, same rule applies with respect to a broker. An insured comes in or a customer comes in, calls, online, whatever it may be, and they identify they want a specific amount of coverage. It's reasonable for the broker to rely on that information and take the order and provide that service to them in that particular policy amount. The reason for this, both with respect to the agent and the broker, is pretty straightforward. But I do want to point out, because when we get to the exceptions, it's gonna flip a little bit. The insured generally knows more what they want. They have a better breadth of knowledge as to what type of premium they can afford, what type of limits they need, what they're willing to pay, what insurance amounts are truly going to cover their losses. You know, by way of an example, say an insured drives up in a Maserati and comes in and is talking to an agent or broker about their beautiful home by the beach, etc., but is seeking to get some sort of commercial policy. It's really disjointed, and there's really no connection there that would lead a broker and agent to believe that whatever the insured is asking for with respect to that commercial policy isn't sufficient. The fact that they drive a Maserati, the fact that they have a beautiful house by the beach, has nothing to do with what insurance they're actually obtaining. Therefore, the fact that they are seeking a $500,000 CGL or whatever type of policy it may be, isn't really for the broker agent to question if that's what in fact they're being told to obtain. It's ultimately not the responsibility of the broker or the agent to figure out what is best for the insured unless certain circumstances apply, which wouldn't apply right now. Then we get to the exceptions to this. So you have the general rule saying there is no duty to talk about what type of additional coverage may be necessary in terms of dollar amount. There are really three primary exceptions to this rule. The first one is the long-term relationship. And this is a little bit of a dicey issue and a dicey area for me and for most of our clients. And the reason is because in your business, the reality is the goal is to build those long-term relationships. The goal is to have those long-term renewals, both in terms of the individual insured or entity and that referral base. With that long-term relationship, however, does come certain consequences. You become very informed in terms of what their prior insurance has been. You may become more informed in terms of what their financial status is. You may become informed in terms of what type of business and risks they really have and are willing to take. All of those things in a long-term relationship may ultimately come into play as to whether a broker and agent does in fact need to provide additional information or different additional offerings with respect to coverage limits. It's unfortunately, in our world, the litigation world, a factual question that isn't typically resolved very easily. It's either resolved during the course of negotiations, during the course of litigation, or sometimes at trial. So that is a little bit of a problem area, only because I know that it is ultimately the goal of everyone here to have those long-term relationships. The second one is holding yourself out as an expert. I'm going to talk a little more in detail about that later because it applies to a lot of issues. But if you hold yourself out as an expert with respect to a particular type of insurance, you're likely increasing your duty with respect to advising the insured of the amount of insurance coverage it should have. The last exception, well, I call it real property, it really relates to whether there's an ascertainable value. Real property happens to be the easy one because if someone comes in and the real property has a value of $2 million, some courts have held that if an insurance broker agent is aware of the value of that real property, they should at least provide coverage sufficient to cover the value of that ascertainable real property value. I haven't seen a whole lot of cases that go beyond real property. I've seen the arguments made that have not made its way to the appellate court, but it's something you should be aware of with respect to policy amounts. If you see a piece of property, and I would even go so far as to say personal property, that has a value and you're offering insurance for that real property or personal property, then I think you should make the recommendation of up to that value just as a safety net. So with those exceptions in mind, and oftentimes those swallowing the general rule, the question then becomes, what is it you should do? I think it's pretty straightforward with respect to the insured's desires. You need to document it, and not only document what the insured is asking, but if possible, document what it is, what their reasoning is for the requested coverage. This can be informal, this can be formal. I personally like it formal, but even if it's a notation in the file, dated, signed by a broker, signed by an agent, knowing that this is what was being offered, it's at least documentation that I as a lawyer, your lawyer, whoever, can point to down the road and say, no, wait a second, this was in fact offered, there was in fact what was requested, this is what they desired, there's a reason they desired this. It's all information that attorneys can use to their advantage later on to sit there and say, no, there's a reason the insured wanted this, this is the reason they wanted it. So all of that's helpful. Equally important is the next point, which is if there were additional coverage amounts offered, make sure that's documented as well. I'm always of the thought process is there's no downside to offering additional coverage. If the insured doesn't want it, the insured doesn't want it. What's important and what often does not happen, though, is the fact that the additional insurance coverage amounts were not documented. So we often have, and I have a case now, in which the insured claims that they were not offered a certain amount that would have been sufficient to cover the loss. Fortunately, we actually do have documentation that relates to what was offered, and that's obviously very helpful to the case. So it does actually come into play quite often. Lastly, if you hold yourself out as an expert with respect to a particular insurance, actually be an expert in that particular area. And again, I'm going to get to that in a moment because that is a very large issue. Next is, as a general rule, this relates to properly recommending types of coverage. And this relates to not actually the amount, but the type of coverage. Again, as a general rule with respect to an agent is not generally personally liable for advising what type of coverage should be provided. They're a little bit more of a order taker, absent an exception applying. Again, the primary exception being that of a insurance expert in a particular field. Again, I'm going to talk about that. I'm sorry I keep punting on that particular issue, but I do want to spend a minute. I'm going to get to it in just a second. Broker, with respect to recommending the type of coverage, it's a little more vague. Reasonable care, diligence, and judgment in procuring the insurance requested. The obvious issue comes down to what was requested. Again, that's a documentation issue. And then you get into what would be considered reasonable care, diligence, and judgment. Well, a legal issue that often is factual based, and that always in litigation tends to extend the litigation a little bit further out because that's generally what the debate covers. Again, the exception to this rule is an express agreement or by holding oneself out as an expert. So the general rule being all you have to do is provide the coverage that's requested, but the exception being that if you're an expert in an area, you're going to say, they're going to assume, they being the insured, that you would be telling them what it is they need in terms of various coverage types. So now I do want to talk about the issue of holding yourself out as an expert. This is probably the most prevalent issue when it comes to recommending types of coverage, whether or not you are an expert. And again, this creates a little bit of a dichotomy in the sense that everyone wants to be considered an expert in their particular industry. You want to tell your insureds, your customers, I'm the best, I know what I'm doing, I'm an expert in this industry, you can rely on me. With that, however, come certain consequences that you're in fact considered an expert and they can rely that you will be telling them, the insured, what it is they need. This is unfortunately often a factual question. And while in the litigation, it used to be personal lines that this was more problematic and more prevalent. It's now becoming more prevalent in commercial lines just because of the nature of the insurance industry, that even commercial line clients and insureds are now relying more so on specific brokers and agents with these alleged expertise. So if I could give an example of what an expert would be in holding themselves out as an expert, for example, a broker agent who is specifically writing insurance for the tow truck associations of California, various tow truck associations. If they're embedded in that particular industry, they're marketing themselves as the tow truck broker agent, they are going to association meetings, they're doing all the things that tell this world that I'm the right person, I'm the person that you should be relying on. That is holding itself out as an expert. Someone who simply says, I'm the best broker agent in the world, you know, I'm a great broker agent consultant, I am an expert in the insurance industry, that is not typically going to be held as an expert in a particular area of the insurance industry. But again, it's a factual question, one that everyone should be aware of. So with that, what's the recommendations with respect to recommending types of coverage? Again, straightforward. If you're an expert, make sure you're an expert in that particular area. I gave the tow truck example. That would be an example of someone who really is an expert in that particular area. Medical and healthcare tends to be another area where you really have to hold an expertise and market yourself as an expertise. But if you are marketing yourself as an expert somewhere in a particular industry, then you need to really make sure you embed yourself, you understand the knowledge, you understand the policies, you understand the industry as a whole. Again, documentation is always critical with respect to the types of coverage that are available. Make sure you do advise and do document what was provided as an offering, what was ultimately chosen, and why it was chosen. The next one is the failure to obtain the actual requested insurance. This is obviously different in that the insured actually requested X insurance, but didn't get X. This is really becoming more prevalent for a couple reasons. One, technology, be it internet or be it just the methodology of obtaining insurance, and the fact that exclusions are now changing at a greater pace than coverage. So what we're seeing in this particular area is not that the broker or the agent are actually not getting the correct policy that they believe is accurate, or not getting the correct coverages that they believe to be accurate. What's occurring is what they think they're obtaining on behalf of the insured isn't actually what they're obtaining, because the exclusions, while bordering on the area of illusory and making the contract illusory, are sometimes swallowing the coverage that the insured believes that they are obtaining for their particular needs. So that is where it really occurs. There are some times when there's the ever so often the insured asked to obtain, $1 million policy when in fact they only obtained a $100,000 policy due to some either Scrivener's error, typo, whatever it happens to be. But that's the outlier. The real most common is a lack of understanding with respect to what coverage is actually being provided within the policy, largely due to the exclusions. Agents, again, the liability is generally going to flow upwards. So as long as they are acting on behalf of the insurer, the liability is typically going to flow to the insurer. There are cases out there that actually question that and say that in a particular instance where the insurance has failed to be obtained, it is ultimately the agent's responsibility. I question that. I actually think it falls within the general rule that if an agent's acting within the scope of its employment with the insurer, the liability is going to flow upwards. Problem is obviously indemnity and relationship issues with respect to the insurer. Exceptions to this would be misrepresentations as to the scope and fraud. Those are pretty straightforward. Liability is always going to be an issue that may flow up to the insurer with respect to an agent, obviously not with respect to a broker. Broker general rule still applies. Duty to obtain insurance requested by the applicant. Going to be a question of fact as to what was actually requested. The general rule is interesting. This may constitute actual negligence if they don't get what was initially requested. I would put that as a will. There's always actionable negligence. It's only a question of damages at that point. Reason for this is very straightforward. Insured should be able to rely on the broker's representations of coverage without independently verifying it. If an insured comes to you as a broker and you tell them they're going to obtain X in coverage, they have a right to rely on that. Recommendations, again, documentation. Document what the insured's knowledge is and why they requested the policy and exactly what it is they requested. Double check, make sure that's what they're obtaining. Also, and most importantly, we now tell our agents and brokers, identify in a cover letter or an obvious document all the exclusions in the policy. You don't have to necessarily go in great detail as to what they are, but at least make a notation so the insured knows to identify and look at those particular exclusions. Failure to add additional insurance to a policy. I'm not going to go spend a lot of time on this because it's the same issue. It's the same failing to get the correct insurance. So it's going to apply the same legal analysis with respect to procuring the requested coverage. Same law applies as that we discussed above. And the same recommendations, except make sure you have a list of all the additional insureds. Make sure that any additional insured list is provided to you from the insured, and make sure that to cross-check, double-check, and make sure they're added. So my conclusion on this particular issue is making sure that there's a lack of, that you have the documentation. It's always the same problem. It's a lack of documentation resulting in a he said, she said dispute. In those instances, in those cases where we do have the documentation, it is a very, very straightforward issue, and the case concludes very quickly. So if you identify what was offered, when it was offered, how much the insured wants, what the insured wants, why the insured went with what they went, it makes the case very clean and very easy for the lawyers. So now the next question becomes what to do when an insured suffers a loss. Typically, It's always the same. There's a loss, and the loss is either not covered or there are insufficient policy amounts. What then happens is there's a claim, there's litigation, or there's a DOI complaint, or some combination of. Two types of lawsuits that ultimately occur with respect to the lawsuits are independent actions, which is basically a broker malpractice or an agent malpractice lawsuit for broker negligence, which may include consequential damages or attorney's fees, or a bad faith type lawsuit. And that occurs because ultimately the plaintiff's attorney doesn't understand the difference between the carrier, the GA, the MGA, the broker, the agent, so he ends up suing everybody within the chain. That's not unusual, unfortunately. It's becoming more prevalent as you deal with non-admitted carriers, you're dealing with GAs and MGAs, and you're dealing necessarily with plaintiffs' law firms who don't necessarily understand the industry as a whole. In the event of a lawsuit or a claim, the steps you want to take are, number one, always contact your attorney. Most of you have an attorney contact. Be sure to get in hold of them as soon as possible just to get their sound reasoning, get their advice as to next steps. They will probably tell you what I'm about to tell you in large part, which is immediately tender to your insurance carrier, gather all relevant documentation, and do not admit wrongdoing or offer any settlement to the insured. You can take the information from insured, but don't offer them a settlement or admit to any wrongdoing. This may impact your errors and omissions coverage. Pass it on to your attorney. Your attorney can deal with that and make whatever offers, communications with the insured for permission are necessary. DOI complaint, similarly, get in contact with your attorney, calendar response date, thoroughly review the letter and customer file, contact the insured, document a response, and give that to your attorney, and provide an accurate accounting. It's what you would expect, but basically you want to gather all the information you possibly can and provide that to your attorney if your attorney is going to provide the written response. If you want to do it yourself, I'd recommend drafting a response, taking all the steps, gathering documentation, putting in file, and still having someone review it. Last but not least, I just want to point out, because it is something that pops up regularly, is making sure you maintain your E&O coverage. There is a tendency sometimes for some producers, some agents, especially early on, to not have sufficient E&O coverage. There are statutory requirements for an LLC, not necessarily for a corporation, but always good practice to have that. The amounts are obviously on the PowerPoint in the insurance code, which is 1647.5, but it is something you should be aware of, and it's very important. Last but not least, with respect to coverage, I want to make just a couple quick points because I think it's important. When you do your E&O coverage, you might want to consider choice of counsel. If any of you out there already have your own attorney, you want to talk to your E&O carrier about adding them as their attorney of record. That way you have an opportunity to use them when anything pops up. Also consider D&O coverage and regulatory coverage. D&O I always like to highlight because, especially in a corporate setting, if a business practice becomes an issue, oftentimes there's class actions for business practice. D&O is a coverage that will likely often provide coverage because it's a business decision as to a business practice that was made by a board, director, or officer. And that can provide a great avenue for providing a defense or coverage to a particular case. So that is a summary of everything. I do want to see, I do believe there are a couple of questions. First one is in what circumstances is a broker or agent liable on homeowners insurance when a replacement cost estimate proves to be insufficient? For example, where a broker or agent recommends as a replacement estimate different from what the insurer's software produces. This is actually going to be a factual question, and it's going. I wish I could provide an easy answer to that, but it really is going to be based on what the insured is communicating to the broker and what the insured is communicating to the agent. I think I'd have to get a little more facts with respect to the question because I'm not sure I have all the facts and ability to answer that particular question. So whoever happened to send that to me, if you want to email me or call me directly, I'll be happy to answer that, go over with you a little more in detail because I think I need a little more facts to answer that. Unfortunately, I went a little slower than I anticipated, so we are out of time. Like I said, if anyone has any questions, they want to email me directly. If they want to contact me, they can do it by email or by telephone. And like I said, we'll be mailing out the presentation material very shortly. Thank you very much.
Todd, listen, thank you very much. This is Steve Young again. Thank you so much for your comments and your insights on E&O. I just wanted to remind the group, as Todd mentioned at the beginning, that there will be 2 additional webinars as part of this series, first on employment law, and then secondly on protecting trade secrets and other proprietary information in the digital age. For more information about those upcoming seminars and also to register, go to our website, which is www.iiabcal.org. That concludes our webinar today. Thank you very much for your participation, and we also appreciate your membership very, very much.